So welcome everybody to meeting number 34 of the House of Commons Standing Committee on Health. Pursuant to the order of reference of May 26, 2020, the committee is resuming its briefing on the Canadian response to the outbreak of the coronavirus. We are meeting today for the purpose of debating the notices of motion in Mr. Genero's name. If a member wishes to intervene in debate, they should use the raised hand function. This will signal to the chair your interest to speak. In order to do so, you should click on participants at the bottom of the screen. When the list pops up, you will see next to your name that you can click raise hand. So we have completed one motion. Mr. Genero, I will give you the floor to move your next motion, please. Mr. Genero.
Thank you, Mr. Chair, and good to be back for another meeting here at HESA. I know this has probably got to be the hardest working committee we have out there, so appreciate everybody taking time on a Monday to join us. Do want to begin. We have three more motions to go, Mr. Chair. I do want to bring the next motion forward, and I'll read it here for you. Pursuant to Standing Order 1081A, the committee send for the following documents to be provided by the government by May 3rd, 2020, by Monday, August 3rd, 2020, and that the documents be published publicly on the committee's website by Monday, August 10th, 2020. All documents, briefing notes, memorandums, and emails to, from, between Health Canada, the Public Health Agency, and the Privy Council Office related to the issuance of medical device establishment licenses, MDELs, between March 1st, 2020 and May 11th, 2020, including all documents, briefing notes, memorandums, and emails to, from, between Health Canada, the Public Health Agency of Canada, the Privy Council Office related to the recall of N95/KN95 masks. Now, Mr. Chair, again, we're trying to get to the bottom of some of the discussion in the government's response. I think all committees all members of the committee are interested in getting those responses. I'd be wondering if you'd be amenable, Mr. Chair. I know in the last meeting we passed the motion that amended the date of August 3rd to August 31st. And then we also amended the date August 10th to September 7th. I'd certainly be willing, if it's appropriate, to amend these so they're consistent with the last motion. Not sure if you need a unanimous consent or if you need another motion for that, but do want to just make you aware that that's certainly amenable on our side.
I would ask you to just make the change. We will consider it moved in that manner. So if you could just clarify. So, I mean, maybe just reread the motion with the dates as you now propose them would be helpful.
How about I read the first paragraph, Mr. Chair?
Absolutely.
It's only impacting the first paragraph. Okay, pursuant to Standing Order 1081A, the committee sent for the following documents to be provided by the government by August 31st, 2020, and that documents be published on the committee's website by September 7th, 2020.
Okay, thank you. So moved. So is there any discussion on this motion? I see Mr. Fisher. Please go ahead.
Thank you, Mr. Chair, and just going to see if what Mr. Genero thinks of this. I think that this motion is almost identical to a motion that was passed by OGO. And the documents are already being produced for August 10th. So I'm wondering if Mr. Genero would consider withdrawing this motion because of this overlap. And I'll read this for the benefit of Matt here and the rest of the committee. Let me see, the motion passed in OGO on June 5th is as follows. Kelly Block moved that in the context of its study of the government's response to the COVID-19 pandemic and pursuant to Standing Order 1081A, the committee send for the following documents to be provided by the government by Monday, August 3rd, 2020, and that the documents be published publicly on the committee's website by Monday, August 10th, 2020, and that departments tasked with gathering and releasing the following documents do their assessment and vetting as would be done through the access to information process. All briefing notes, memorandums for information, memorandums for decision, documents related to the Wednesday, March 18th, 2020 interim order by the Minister of Health entitled Interim Order Respecting the Importance and Sale of Medical Devices for Use in Relation to COVID-19, all briefing notes, memorandums for information, memorandums for decision, and documents related to the Monday, March 30th, 2020 interim order by the Minister of Health entitled Interim Order Respecting Drugs, Medical Devices, and Foods for a Special Dietary Purpose in relation to COVID-19. All briefing notes, memorandums for information, memorandums for decision, and documents related to the issuance of medical device establishment licenses, MDELs, between Sunday, March 1st, 2020 and Monday, May 11th, 2020. All briefing notes, memorandums for information, memorandums for decision, and documents related to the issuance of medical device licenses, MDLs, between Sunday, March 1st, 2020 and Monday, May 11th, 2020. And finally, all briefing notes, memorandums for information, memorandums for decision, and documents related to the recall of N95, KN95 masks, including documents pertaining to the Monday, May 11th, 2020 MDEL bulletin produced by the Medical Devices Compliance Program. So this passed unanimously at the OGO committee, and I think if, and I'm sorry for maybe reading it a little bit too quickly and not having the benefit of having the committee have all of these things that were moved. It seems like everything that Mr. Genero is seeking on behalf of this committee is in this motion, unless I'm missing something. So I'm wondering if perhaps taking the findings of OGO and maybe even putting them on the health committee's website by that particular date might do the same thing that Mr. Genero is seeking of this committee.
Thank you, Mr. Fisher. Mr. Genero is not next to speak, but I'll let him interject if he wishes to respond.
Thank you, Mr. Chair. I appreciate Mr. Fisher's attempt to, I guess, speed this up. Do just want to point to previously we've discussed the importance of our committee being separate from the OGO committee. The OGO, we don't control what the OGO committee does. They don't control what we do. Certainly, I think having more information from the OGO posted on our website would help. But at the end of the day, we want this to be as comprehensive report as possible and not simply just say in a line, oh, by the way, go look at the website regarding OGO. So, you know, I would, I think we agree on some of the perhaps the wording there, but I still think it's the due diligence of our committee to go and make sure that we pass our own motions to this regard. We don't know what OGO will intend to do with the rest of their information or what type of report they do. So, you know, I appreciate the spirit of it all, but I think it's still incumbent upon our committee to pass our own motions here.
Thank you, Mr. Genero. Mr. Kellaway, you're up next.
Thanks, Mr. Chair. I put up my hand prior to Darren speaking to a certain aspect of the motion, but just to comment on the time change that Mr. Genero put forward, I think it's spot on. It's something that I was going to highlight just in relation to the notice of motions that were given on June 12th with requests that documents be produced by August 3rd. That was about 7.5 weeks, and I think pushing it back to August 31st and September 7th, respectively, is appropriate. And but I'll chime in a few minutes on this item as well.
Thank you, Mr. Kellaway. Mr. Davies, go ahead.
Thank you. Well, I guess my first question that I'd like to maybe get Mr. Genero's position on is, does he agree that the motion that Mr. Fisher read out covers the same material as is covered by his motion? Because if it does, then obviously the information is going to be gathered by the civil service, and perhaps we could just request that information be sent to our committee at the same time as it's sent to OGO, since it's already being gathered. But if I'm curious if he thinks that there's a difference in the information being sought, because that may make a difference.
Thank you, Mr. Davies. Mr. Genero, please go ahead.
Thank you, Mr. Chair. I anticipate that we're going to probably have a discussion about emails being included. Obviously, this motion includes the emails as being part of that. If you know, I certainly still believe that the emails and as much information as possible is what we intend to gather. So I would point specifically to that part of the motion here. When it makes a little nervous after last committee's meeting that we with the discussion about ATIP versus the parliamentary council being able to produce documents and vet the documents. I would suggest again that the committee accordingly look to the law clerk and parliamentary council based on their information that they provided at our previous motion. So I guess the outside of emails, that would be the other skeptical point I have. But again, certainly eager to not put a huge burden on the public service, because if they're doing this work already with OGO, then it should be simple. It should be able to provide a lot of that information to us. But again, based on those 2 points, I think our motion is slightly different.
Thank you, Mr. General. Mr. Fisher, go ahead.
Thank you, Mr. Chair, and I understand where MP General is coming from. I think that it would be another task for public servants then to collect all these documents, other than being given the opportunity to just go and find out what was presented to OGO and put on the OGO website. It's not a hill I want to die on here, but it does seem like less efficient way to get the exact same documents. So I do think that there's value in allowing OGO to do that, and then finding out what is presented to OGO. And I don't see any gaps. Mr. Davies asked if there were any gaps. I don't see any gaps. In fact, the motion that Ms. Block moved was so fulsome that I think it covers this and more. So I know it's not appropriate to move a motion to withdraw Mr. Genero's motion, and I never would do that. But perhaps, we'll see where we go with this particular motion. Thank you, Mr. Chair.
Thank you, Mr. Fisher. Mr. Killaway, please go ahead.
Yeah, thanks, Mr. Chair. Just briefly, I mentioned at the last meeting that obviously I'm relatively new to politics, but I do think in this case, when you look at OGO, and I stand by what I said at the last meeting, and I use the words transparency and consistency and efficiency are not mutually exclusive. And I think in this case, I think we would achieve the same results, but that would be my 2 cents on it at the moment.
Thank you, Mr. Killaway. I'm sorry, I was focused on a text here. Did you move the motion to amend?
Are you speaking to me, Mr. Chair?
I missed part of what Mr. Killaway said. So, So I was just wondering if he made a motion. No, okay. I'm caught up now. So thank you.
Okay.
Is there anyone else who wishes to speak to this amendment or to this motion? Mr. Fisher, please go ahead.
So moving on from seeking withdrawal, and Mr. Genero predicted this would happen. I would move that, as we've done at all of the other committees and all of our other motions here, to remove the emails and take away that onerous level of work for our public servants that have served us so well during COVID-19. So I would move that we would do the same thing we've done in the past, emails being removed from all of our motions as they have been from all the committees.
Thank you, Mr. Fisher. Of course, we can only move to amend the current motion. But is there any discussion on Mr. Fisher's amendment? Mr. Davies, please go ahead.
Thank you, Mr. Chair. I know I missed the riveting discussion at the last meeting over these issues, so I'll try to be succinct, but committees have extensive powers of production for a reason. I've sat through a number of parliaments and seen various governments approach to control committees. And I know the present Liberal government, since they won election in 2015, has pledged on a number of occasions to restore the historic position of committees to fulfill our very important mandates, to act and operate independently and to be masters of our own business and affairs. It would seem to me that if we start falling into the practice of always excluding emails from production, it would be completely and ridiculously and patently easy for any government to effectively avoid accountability to committees by simply putting all information that they want that's sensitive into email form. That's number one. There is nothing, and it defeats the very purpose of the committee's power to produce and compel documents, just like we can compel and produce witnesses. And I think we all as committee members, regardless of political stripe, have to take our responsibility seriously with respect to these powers, and not fall into a practice that effectively lets any government of any stripe avoid its trans. Said before, frankly, I think emails are among the easiest things to gather because there are search functions on computers. It's way easier to get emails by putting in key search words than it is to gather paper, which really does require sometimes a Herculean search process through Ottawa, as a number of civil servants have to search files and desks, etc. So I don't buy the argument that emails are difficult to get. Third, these motions that we're dealing with here are dealing with targeted issues. This is not opening up the entire civil service and to all their emails. It's emails that are related to specific issues, the N95 mask issue, the medical devices. So I can't imagine that there's thousands of these emails. I mean, we're talking about hundreds or maybe dozens. So I'm going to speak in favor of this. I'm always going to speak in favor of transparency and accountability. I think any government has a valid point to be careful and vigilant to ensure that this process, this very special process that committees have, isn't abused or doesn't create true and authentic bureaucratic nightmares. But I don't see that in this particular case. And so I'm going to speak in favor of this, and I hope all of my colleagues do. The fact that this information is being gathered, I think it speaks to Mr. Generou's point already that the government's already gathering most of this information. And finally, we haven't yet spoken on redaction. I'm going to repeat now and early that I was extremely disappointed with the extensive redaction that occurred by I don't know who to documents that this committee had requested before. And frankly, it was insulting to committee members that we were denied the ability to see documents and to read them in their fulsome form. There should be only 3 reasons for redaction. 1 is privacy, 2 is cabinet confidences, and 3 is national security. And the only person that should be doing the redaction is the law clerk, or perhaps the clerk of this committee. So I'll foreshadow what I anticipate will be the next amendment by the government to try to restrict the information to ATIP or something else that has many, many criteria to it that I'm not even sure. But I've done enough ATIPs in my time to know that you get documents that come back with more black than you have words in them. And that defeats the purpose of holding the government accountable as well. So I'm going to speak in favor of the motion as it's currently written, and I urge my colleagues to do so. Thank you.
Just to clarify, we're debating the amendment by Mr. Fisher, which is to remove the emails. So if I take it from your discussion that you're actually opposed to this amendment, right?
Yes, you take it correctly. Thank you, Mr. Chair.
So we go now to Ms. Jansen. Please go ahead.
As I said at the previous meeting, it's so important that we win back the trust of Canadians. And I can tell you, I've been out in the community and we've lost it. We've completely lost their trust. And when we decide that we're going to not allow emails, which everybody recognizes, you know, are they're good bits of information. We need to have those kinds of information to truly understand what happened, why science supposedly changed, and so forth. And the only way to do that is to have, you know, an honest opening of the books. Lay it all out there. Let people understand why the science changed. Let them see what happened. Why are we suddenly told we need to wear masks? I'm just absolutely stunned at the anger in the community right now at people like us. You know, we continue to not show truth. We continue to cover stuff up. And if we cover it up and we at the same time are destroying our economy, you can imagine that people are going to continue to be very upset. So I'm begging you, we need to show that we're going to be fully transparent, as I understand was the obligation of this Liberal government, was to become fully transparent. And if we don't, we will lose the trust of Canadians. So I'm against this amendment.
Thank you, Ms. Jansen. Mr. Pawlowski, Dr. Pawlowski, please go ahead.
Thank you. Well, first of all, let me say I agree with a lot of what Mr. Davies said about transparency. Having worked a lot of years in a lot of developing countries, I certainly note that the world is inundated with Canadians who go to other countries who preach the importance of transparency and accountability, and yet you come back to Canada and sometimes we don't seem to have the same enthusiasm for transparency and accountability in our own country. So I fully appreciate and I fully agree with the importance of transparency. I would think I am in favor, however, of the amended motion, which is to remove emails, and I think it's because of the practicality. Certainly, the Department of Health is under immense pressure to do all kinds of things. I don't think there's ever been a time in our history where the department has been overworked like they are at the moment. There's just kind of no end to the number of issues that they have to be dealing with, and a lot of those things don't even come to our attention. There's things like ECMO, which is I don't even want to say, but there's all kinds of medical issues, epidemiological issues that they're dealing with, and this is obviously in having to produce documents, taking them away from their other tasks. And although I can appreciate the number of documents, emails may be limited, there's all kinds of motions, and when you start adding these all up, it seems it's producing a lot of stuff. And in emails, I think too, there's going to be a lot of discussion about, for example, with the provinces, what the provinces are doing. And I think you want to be, when you're communicating with other members of government, being honest as to your appraisal of the situation. But in doing so, you may be saying things which other levels of government, like provinces, may not really appreciate your candor. So I think there is reason to want to be a little prudent in what is released. And so I too am foreshadowing. I think there will be other amendments to this, but I think the email limitation seems to me a reasonable one, to not include emails.
Thank you, Dr. Pawlowski. We go to Mr. Van Bynen now, please.
Thank you, Mr. Chair. And I agree and I support the fact that we need to be seen to be transparent. But I do take issue with the statement that people have lost trust in their government. I make specific efforts to reach out to my constituents, and that's not what I'm hearing from my constituents. What I am hearing from my constituents is that they would like to have things go forward. And when we come to the email issue, I think a number of those discussions would be covered by briefing notes and memorandums, and that would satisfy the information that's being sought as well. And I know that there was the statement also made that it would be very easy to search your emails, but I think in situations like this, it's the text of the messages that would be the key item. You can't simply search by sender and receiver. And I don't believe that any of this can be delegated to someone else. So back to the earlier points, is we're taking people away from an important job, and that job is to deal with and to respond to what the community needs today. So I would be supporting removing emails. And again, it's because I believe that the briefing notes and the memorandums will satisfy the information that we're seeking, and that it does not in any way infringe on the transparency. And in fact, I think it's a matter that would undermine the trust of government to suggest that there's things there that shouldn't be brought forward. I believe that the information we need, the information that we're seeking, and is going to be available without including the emails. And so I will be voting in support of that motion.
Thank you, Mr. Van Bynen. We go now to Mr. Kellaway, please.
Thanks, Mr. Chair. MP Van Bynen said a lot of what I was going to say around emails, and certainly there is a search function that would be able to certainly bring a lot of emails at one time. But again, it's a matter of going through them, and it is the individual that sends or has received the email. You can't delegate that to someone else. So I make that point. Let's put it on the table. I mean, everybody on this Zoom is for transparency. Everyone is for accuracy, but it astonishes me to a degree that, you know, can we not be efficient? Can't we achieve both? Clearly, that's not the case, and we'll be voting on that. But I think you know, Canadians are focused on transparency and accuracy, but efficiency. And so I'll be voting for the amendment, obviously, going forward. Thank you.
Thank you, Mr. Kellaway. Ms. Jansen, please.
I find it very interesting that you know, Mr. Kellaway and Mr. Van Bynen say that there's nothing in them to hide.
Ms. Jansen, you might want to check your microphone to make sure the right one is okay.
Sorry, I had it up. I find it very interesting that Mr. Kellaway and Mr. Van Bynen suggest that there's nothing in them in the emails to hide, and Mr. Pawlowski says that we might embarrass provinces from what's written in those emails. We're not about embarrassing people. We're not about trying to, you know, cover up for anybody. And I think that, especially with Dr. Pawlowski's statement, you know, that there could be things in there that the provinces have made mistakes on. It's a very important thing to have those emails. I mean, if we want to protect Canadians going into the fall, going into winter, we need to know what went right, and we need to know what went wrong. And to be not transparent, and I know we all want to be transparent, we all want to be efficient, and the way to do that is to allow these emails, and especially with Dr. Pawlowski's suggestion that there are provinces that have made mistakes, and that will be evident in the emails.
Thank you, Ms. Jansen. Is there any further discussion on this amendment? Ms. I see your hand raised.
I felt compelled to say I didn't say necessarily the provinces made mistakes. I think that people ought to be, and the bureaucracy and people in the ministry ought to be open to discuss the management. And sometimes that may not be appreciated by other parties like the provinces, their discussion of how they managed it. I didn't mean to, and I don't think I said that they necessarily made mistakes.
Thank you, Dr. Pawlowski. Is there any further discussion on this amendment? Ms. Sadhu, I see your hand up. Please go ahead.
Thank you, Mr. Chair. We want to know too, the purpose of the motion, Mr. Chair, is we want to get full picture of the situation. And we respect that, but briefing notes and the memos would satisfy, I think, the reason. And as you know, the volume for emails is particularly very large for the time period. And we, as Mr. General said, we want to know as soon as possible. We want to know too, and we want balanced the transparency. We want transparency too. I think I'm in favor of removing emails for privacy purpose, and the main purpose of the motion is solved with the briefing notes and the memos, and what we want to know. We can get the answer, and we can carry on as soon as possible. I think it's reasonable to us to remove the emails. Thank you.
Thank you, Ms. Sadhu. Is there any other discussion on this amendment? Is there Monsieur Desilets, please go ahead.
Oui, merci.
Thank you, Mr. Chair. I'm so sorry about earlier. I had a little technical difficulty. After what Mr. Fisher said, I do agree that we should not ask for emails.
And the interpretation at the equal, and it's hard to hear.
Thank you, Mr. Van Bynen. Monsieur Desilets, could you check to see that you are on the French channel? On the bottom of the screen?
Je suis dans la chaîne française.
I am on the French channel.
Maybe try your intervention again, if you wouldn't mind.
OK, je vais reprendre.
Okay, I'll start again. Following Mr. Fisher's suggestion, I completely support it.
The translation is coming through at a lower level than on the English channel. It's coming down at a lower level than your voice in French, which is eloquent and beautiful, but it's hard to understand. So I wonder if the interpreters could verify that the setup for the translation from French to English is correct. Madam Clerk, if you would mind just advising us when that, if that is adjusted.
I'm being told that it's fine from the interpretation booth.
Okay, because it's very difficult to hear Monsieur Desilets because his voice in French is coming in on the French channel, on the English channel at a higher level than the translation is, right? It should be coming in at a very lower or subdued level. So maybe we'll suspend for a couple of minutes and get this sorted out. Desilets, Monsieur Desilets.
Correct.
possible to remove emails, as many of my colleagues have proposed. So what we will gather will be able to will be used by all committees, and that way we'll be able to better use the work of the public servants. And this is it for me. I'll try to not intervene. I'll try to intervene as little as possible today. Thank you.
Thank you, Monsieur Desley. Your sound is good as far as I'm concerned, and the interpretation is working. So feel free to intervene as much as you need to. That having been said, is there any more discussion on this amendment? Any more discussions? Seeing none, I will ask Madam Clerk to conduct a vote. So the vote is on the amendment to remove emails and appropriate grammatical corrections, adjustments to the motion as may be appropriate. So, Madam Clerk, if you please conduct a roll call vote, please.
Thank you. Ms. Jensen.
Ms. Johnson, you're here.
Sorry. No. Mr. Généraux.
Also no, but just a quick point of order, Mr. Chair. I believe that the clerk, who's new to our committee and doing a fantastic job so far, usually it starts at the government side and then goes to our side in terms of votes. At least that's the precedent we've set at this committee. So just if we could clarify that, thanks.
Chair, would you like me to start over?
Sure, that would be fine. Thank you.
Mr. Fisher.
A yay to the amendment.
Mr. Kellaway.
Yes to the amendment.
Mr. Pawlowski.
Yes.
Ms. Sidhu.
Yes to the amendment.
Mr. Van Bynen.
Yes to the amendment.
Ms. Jensen.
No to the amendment.
Mr. Généraux.
No.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets. Monsieur Desilets.
Mr. Desilets?
Oui. Mr. Davies.
No.
Mr. Chair, I have 5 nays, 6 yeas.
Thank you, Madam Clerk. So the amendment carries. Is there any further? So we're back to the main motion, which has now been amended to remove emails from the request. Is there any further discussion on the main menu as amended? The main motion as amended. Mr. Fisher, please go ahead.
Mr. Chair, I just want to know, based on what Mr. Généraux said there, if we could ask the clerk for clarification on where I've been on multiple committees where it's gone back and forth at different times. And I know that in the health committee, we've always started the government side, but is that something that we need to do?
Madam Clerk, if you care to respond, please do so.
We can do it different ways depending on the committee. We can also do it alphabetically with all the members. With virtual committees, I think that we are kind of readjusting ourselves. But if the committee has a practice of calling the government side first, I'm happy to continue with that practice.
Thank you. Mr. Fisher, did you have further intervention? I see your hand still up.
No, my hand just didn't come back down. I don't really have a problem with the way we did it. I just, whenever we did it that way, I just thought back to my past committees and thought that it just seemed kind of strange that we always did it that particular way. And I wasn't sure if that was a precedent that we set or is it just a thing based on different clerks. So it's all good.
Thank you, Mr. Fisher. So any further discussion on the main motion as amended by Mr. Fisher? Mr. Fisher, please go ahead.
Mr. Chair, we have, again, at this committee on the past few motions, we talked about adding in the vetting line. So I will move that now, that we would add in at the end of that motion, provided that the department does its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process.
Thank you, Mr. Fisher.
So I'll just, if I could just speak to that for just a quick second. A lot was said at the last committee meeting about how we ended up with a motion that had more redactions than the committee was happy with. And the wording, I've just got the wording here of the motion that we used, which, and I'll put it out there for the committee's thoughts on this, but it seems more like what we did last Monday when MP Kwan had amended the motion. And we had come to an agreement with that and we passed that. But this is the wording that gave us the response that was more redacted than we wanted it, which is what led us to move forward with conservative vetting language from previous committees. So this was what we had passed back in the day that provided less volume than or detail than we'd wanted. Further, that matters of cabinet confidence and national security be excluded from the request, and that any redactions to protect the privacy of Canadian citizens whose names and personal information may be included in the documents, as well as public servants who have been providing assistance on this matter, made by the Office of the Law Clerk and Parliamentary Counsel of the House of Commons. That's the wording that we used that gave us the documents that we felt were more heavily redacted. So we felt that the wording, provided that the department does its assessment and vetting and gathering and releasing the documents as it would be done through the access to information process, which is a process passed by Parliament, made more sense and would likely give us more of what the motion is seeking. And as moved again, and I know Mr. General loves it when I read conservative motions into the record, which I won't do now, but we've seen that passed at various committees with that wording. So I will move that amendment.
Thank you, Mr. Fisher. Go now to Ms. Sadhu. Mr. Sadhu, go ahead.
Thank you, Mr. Chair. Why I'm saying this, because the assumption that we want transparent on this issue, we want to know exactly what happened in our, for example, long-term care homes. We want to get all the information possible. Given that I have one of the long-term care home in my writing, the CFA report, we want to protect privacy. And any information coming out of the CF report. That is why I want to support Mr. Fisher's comment.
Thank you, Mr. Du. Mr. Du, your sound is very broken up. I wonder if you could just maybe check your connection, make sure that it's plugged in properly, and maybe,
Sure, Mr. Chair, how's that?
It's still bad. I could understand. I'm not sure if the translation would be able to have translated, but it's kind of sounds like a bandwidth issue. So if there's anything on your network that you could kind of stop, that would maybe be helpful. Anyway, we continue with Dr. Pawlowski, please.
I too accept or support the amendment, including ATIP language. The OGO committee voted in favor of including the ATIP provisions, and I think all parties agreed with that. I too have concerns about overly redacted documents. I think democracy in a nutshell is that the unelected bureaucrats are held accountable to the elected individuals, which are us, and we too are then held accountable to the population in terms of an election. And certainly to have that accountability, you need to have transparency. So now, having said that, I think there are actually some genuine good reasons for excluding some information and not making those public. For example, personal information that could be detrimental to individuals. I mean, and especially this, I think, is going to be more the case when it comes to the motion on chronic care homes, but also information relating to our relationship with the provinces. There may be some sensitive information there. Certainly, in managing this pandemic, I think we have had good relationships with the province. I think we want to continue to have good relationships, and we don't want to jeopardize that by forcing us to reveal all documents, some of which potentially may affect our relationships with the provinces, and that is included in the ATIP provisions. So the ATIP provisions seem to me to be reasonable. Now, if it comes back that it's overly redacted, then I agree with the opposition. But this is a change from the previous. When was that? The February motion, and hopefully this will give us better results in terms of not overly redacted documents.
Thank you, Dr. Pulaski. We go now to Mr. Genero, please.
Thank you, Mr. Chair. Would certainly agree to amend it similar to what our motion was on last week. This, however, is again, so the committee members are clear, this is what happened in February. The government went and chose to redact certain portions of it. The motion that passed on last Monday was the Office of the Law Clerk and Parliamentary Counsel, who then is provided the opportunity to provide those redactions for privacy concerns and a variety of others. So would certainly be amendable to changing the motion to similar to last Monday's motion, but this Monday's this motion certainly doesn't achieve what the government is saying that it intends to achieve.
Thank you, Mr. Genero. Mr. Davies, go ahead.
Thank you. Well, for sake of completeness, there's a very, very important, there's some important points of information to follow up Mr. Fisher's point, which I'm afraid leaves an extremely misleading impression to this committee. And that is his suggestion that it was the wording of the motion back in February that led to heavily redacted information. That is not true. He did read out the motion that we made back on February 26th, and that instructed that the committee order all documents subject to redaction for the points that Mr. Fisher raised. The motion did restrict redaction to protect privacy of Canadian citizens, as well as the other points that were made. But what is being left out is the letter that we received from the law clerk. After that, Mr. Dufresne, the law clerk and parliamentary counsel, dated March 20th, that was sent to our clerk of the committee, Mr. Jacques. And this, I'm going to quote from that letter. On March 15th, 2020, the Deputy Minister of Health Canada provided the committee with documents in response to its production order for the Departments of Health, Transport, Global Affairs, Public Safety, and National Defense. A letter accompanying the documents stated that redactions had been made to protect personal information in accordance with the Privacy Act, and that redactions had also been made, quote, to avoid injury to international relations, as well as relations with the provinces and territories, to protect information considered advice to a minister, for the protection of government assets, and to protect solicitor-client privilege, end quote. The letter goes on to say, these latter grounds for exemption from disclosure are contained in the Access to Information Act. I'm going to pause here and just say this. The grounds for redaction are much broader in access to information than in what we had instructed to the three criteria. in our original letter, which was privacy, national security, and cabinet confidence. The problem was that the department violated the instructions of this committee back in February and applied the ATIP criteria, which is what resulted in the extensive heavy redactions. I'm going to go on to quote from the law clerk's letter to our committee. Upon reception of the documents on March 15th, 2020, you provided them to my office so that we could make the necessary redactions to protect the privacy of Canadian citizens, permanent residents, and public servants as contemplated by the production order. However, as mentioned above, the documents had already been redacted by the respective departments. As my office had not been given the opportunity to see the unredacted information, we are not able to confirm or adopt those redactions. My office did make one additional redaction to the documents regarding a public servant. It goes on in this meeting. During that meeting, we reminded the government officials that the House's and its committee's powers to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations. We added that the House and its committees are the appropriate authority to determine whether any reasons for withholding the documents should be accepted or not, and that it was for the committee to determine whether it was prepared to accept any proposed measure that would prevent the disclosure of sensitive information for any reason. So I'm going to stop there. So here's the actual facts of the matter, is that we can't have departments, civil servants, deciding what they want to redact or not. That is truly having the fox guard the hen house. If the Liberal members of this committee actually believe in the words they're saying, and do believe, as Mr. Pawlowski just said, that it's for elected officials to hold public servants accountable and not the other way around, then we need to insist that unredacted information come to this committee, and it's for us to determine, not civil servants, whether information should be redacted, should be protected or redacted or not, or it should go to the law clerk in unredacted fashion for the law clerk to make that determination, not the civil servants whose very information may be the subject of embarrassment or information that we want to get. So I think it's very important to clarify Mr. Fisher's comments, because I don't want it to leave the impression that the reason that we had such heavily redacted information back in February was because of our limiting of redaction to the 3 criteria. It was in fact the department's violation of this committee's instructions and adoption of ATIP, the broader ATIP redaction criteria, that caused that result. So if this committee does really believe, as Ms. Sidhu just said, and Mr. Pawlowski said, and Mr. Fisher, Mr. Kelway said, if the Liberal members of this committee do believe that it's for this committee to get to the bottom of the issues that are the subject of Mr. Genereux's motions, and to have information for us to hold the civil service accountable, then we will limit redactions to the 3 bases that already are totally justified: privacy of individuals, national security, and cabinet confidences. And that information should not be redacted by any department beyond those 3 criteria. And then the information should be sent to the law clerk. Or actually, the information should all be sent to the law clerk, and the law clerk should be redacting according to those criteria. And so the members of this committee need to be absolutely crystal clear that ATIP criteria for blocking information is far more wide. And perhaps I can ask the clerk to actually specify to all of the members of this committee what the criteria are in the access to information process, so that we know exactly what grounds are used to redact information under ATIP requests before we apply that standard to this committee. Thank you, Mr. Chair.
Thank you, Mr. Davies. So I have next Mr. Van Bynen. However, before we go to Mr. Van Bynen, I'm going to ask Mr. Fisher. I have a note from the clerk to confirm what the amendment is. So what we have is the amendment is to add after the words N95/KN95 masks, the following: providing that the government does its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process. Mr. Fisher, could you please verify that that is the motion?
That is the wording. That is the addition to Mr. Genero's motion.
Great. Thank you, Mr. Fisher. We go now to Mr. Van Bynen.
Thank you, Mr. Chair. The point that I wanted to make is that there is a legal obligation that is placed upon the public service as a nonpartisan party to protect the privacy. That is why this government adopted the ATIP guidelines and rules. And those rules should be sufficient to provide the information that the government is seeking, and those rules should be sufficient or should be relied upon for a fair and equitable and non-biased, non-partisan review of the information that should be excluded for the very reasons that was raised earlier, to protect privacy, cabinet interest, national security, and all of the specifics that are identified in the ATIP legislation. I don't understand why we feel we need to go beyond that. And if so, then why don't we review the ATIP procedures, the ATIP legislation, and make that more encompassing? It was satisfactory when it was adopted. It was adopted by a majority of government. And so why should we change that? Those guidelines are legitimate, specific, and they protect the interests of the government, of all the people that we necessarily need to deal with, other municipalities, other provinces and territories. And so I think we have an obligation to protect their rights. And I believe that that can be done by an independent group of nonpartisan public service officers.
Thank you, Mr. Van Bynen. We'll go back to Mr. Davies, please.
Thank you, Mr. Chair. Well, I think it'd be helpful, again, I would maybe ask that the clerk specify all of the grounds for redaction under access to information so that this committee knows what those grounds would be. And the committee members will see that there's many more grounds for redaction than just the privacy, cabinet confidence, and the national security criteria that we would say that is the alternate, I guess, way of proceeding. I would just, I guess, in response to my colleague, Mr. Van Bynen, just point out one thing that there is a difference between the ATIP process and the powers of a committee to compel production. We're not the same body. We're not a member of the public seeking information from the government, nor are we an individual member of parliament seeking information through the ATIP process. I'm going to remind you that these are the words of the law clerk of the House of Commons. We reminded the government officials that the House's and its committees' powers to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations. The ATIP is a statute. It's a statute that governs the regular process of seeking information from government. That's not who we are in this, and that's not the power and privilege that we are exercising in this case. To accede to that argument is to relegate this committee to the same status as just a regular citizen. That's not what the citizens of this country expect us to do. They have accorded constitutional authority to these committees to get information beyond that. That's what they expect us to do. And so I'd like to hear an argument why the members of the committee that are in favor of this amendment want to clip our wings and circumscribe our ability to get the documents that we need to get in order to truly hold the civil service accountable.
Thank you, Mr. Davies. I note that you've asked the clerk to weigh in on particulars of the access to information process. I'm not sure that the clerk has that information, but I will invite to do so if she feels that it is appropriate.
I'm not an expert on the Access to Information Act. If the committee wishes to have more information on what would be, I guess, the differences between asking for documents under the privilege of the committee versus asking for information under the Access to Information Act, that request or that question would have to be asked to the Office of the Law Clerk and the Parliamentary Council. I would be happy to send the question over to them if the committee wishes.
Thank you, Mr. Chair. If I might, that would be helpful, I think, for future guidance for the committee members. But I will offer this because, in a sense, we already have that in the letter from the Parliamentary Council to Mr. Jacques, the clerk of this committee, on March 20th. And what is said in this letter is, after we had requested that redactions be limited to matters of cabinet confidence and national security and privacy. And the law clerk pointed out that the Deputy Minister of Health Canada went beyond that, and in the letter said this. This is what the law clerk said. A letter accompanying the documents stated that redactions had been made to protect personal information in accordance with the Privacy Act, and that redactions had also been made to avoid injury to international relations, as well as relations with the provinces and territories, to protect information considered advice to a minister, for the protection of government assets, and to protect solicitor-client privilege. These latter grounds for exemption from disclosure are contained in the Access to Information Act. So I'm not sure that that is a complete description, but it gives committee members here a glimpse into what the law clerk is telling us are the additional grounds contained in Access to Information. And some of them, as you can see, you can drive a truck through. I mean, if we're going to let the department redact information, which in their opinion, it's considered advice to a minister, or to that if they think it might damage relations with the provinces and territories, these are so amorphous, they are so subjective, they are so broad that you end up getting exactly what we got in March, which is page after page after page that was blacked out. So if that's what this committee wants, then that's what will happen if we adopt this amendment to restrict or to allow redactions according to the Access to Information Act. We will have those criteria that I just read out. Thank you, Mr. Chair.
Thank you, Mr. Davies. Dr. Pawlowski, please go ahead.
As always, Mr. Davies makes very good points. He's a real lawyer, unlike mine. I am, and I would agree with him from the House of Commons Procedure and Practice, 3rd edition. The standing orders do not limit the power to order the production of papers and records. The result is a broad, absolute power that on the surface appears to be without restriction. Now, having said that, I think, and even Mr. Davies would agree, that there are certain things that you may certainly not want to make public, and I'm not sure by procuring documents and it going to the committee and not making them public, what we're going to get out of it. But there are certainly things which I think it's not in our country's best interests to reveal, and also in individuals' best interest to reveal. There's things like, for example, personal information. I'm sure Mr. Davies agrees with that, but also I think in terms of our relationship, because and Mr. Davies is right, ATIP is very broad and includes withholding information relating to our relationship with the provinces. I have the actual provision if you want to read it at some point. However, that is included in ATIP, but I think there's a good reason for that, because we do have to work with the provinces. Our being able to come to agreements with the provinces, to have good relationships with them, is certainly fundamental in our management of the pandemic. If we were to reveal everything, potentially, I think that could impact our relationships with the provinces. Similarly, there's provisions relating to our relationships with other countries. and not revealing information which may be detrimental to other countries. So I think there is good reason to exclude some material. Now, I would agree with Mr. Davies. If you were to take a really liberal interpretation of ATIP provisions, and as he's indicated, I do have a list of them here. It is very long, all the things which can be excluded under ATIP. I think that the department has to be very conservative in applying that and not just give a bunch of bureaucrats markers and say, go crazy. And if they do, and if these documents come back heavily redacted without any information or with large parts of it excluded, then I agree that's a problem. But I don't think that they will. And I do have faith in the department is supposed to be the department, as opposed to the ministry, is supposed to be nonpartisan, and I do have some faith that they will apply the redactions in an appropriate way.
Thank you, Dr. Pawlowski. Is there any further discussion on this amendment? Is there any further discussion on the amendment? Seeing none, I will ask the clerk to conduct the roll call vote. So the vote is on the amendment as moved by Mr. Fisher.
Thank you. Mr. Fisher.
Yay on the amendment.
Mr. Callaway.
Yay on the amendment.
Mr. Pawlowski.
Yes on the amendment.
Ms. Sidhu.
Yes on the amendment.
Mr. Van Bynen.
Yes on the amendment.
Ms. Jensen.
No.
Mr. Généraux.
No.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets.
Oui.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays. Mr. Chair, you are on mute.
Sorry. Thank you, Madam Chair. The vote carries. The discussion now carries on with the Mr. Généraux's motion as amended. Is there any further discussion on this motion? Seeing none, I'll ask one more time. Is there any further discussion on the main motion as amended? Seeing none, I will ask the clerk to conduct the vote. So the vote is on the Mr. Généraux's motion as amended.
Mr. Chair, just a point of order, are we going again the way we traditionally have gone, or are we in voting, or are we going to shake it up a bit?
I think we should stick with our past practice. If we want to change our practice, we should discuss it at another time.
Fair enough.
Okay, fair enough. Thanks. Please go ahead with the vote, Madam Clerk.
Point of order. We're now. Could someone just read the amended motion that we're voting on?
Sure. Go ahead, Madam Clerk. If you wouldn't mind reading the motion as amended.
Okay. Perfect. So the amended motion reads as following. Pursuant to Standing Order 1081A, the committee sent for the following documents to be provided by the government by Monday, August 31st, 2020, and that the documents be published publicly on the committee's website by Monday, September 7th, 2020. All documents, briefing notes, and memorandums to, from, between Health Canada, the Public Health Agency of Canada, and the Privy Council Office related to the issuance of medical device establishment licenses between March 1st, 2020 and May 11, 2020, including all documents, briefing notes, and memorandums to, from, between Health Canada, the Public Health Agency of Canada, and the Privy Council Office related to the recall of N95, KN95 masks, provided that the government does its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process.
Thank you, Madam Clerk. Is everyone clear now on?
I think, Mr. Speaker, point of order, I think it's that the department does its assessment, not that the government does its assessment.
Okay, Madam Clerk, could you make that change? I think that is what we confirmed earlier.
Perfect.
Okay, thank you. So are we clear now on the motion before us, the motion as amended? Okay, seeing no hands, we shall carry on with the vote. So, Madam Clerk, if you would please.
Mr. Fisher.
Yay to the motion.
Mr. Callaway.
Yes to the motion.
Mr. Pawlowski.
Yes.
Ms. Sidhu.
Yes.
Mr. Van Bynen.
Yes.
Ms. Jensen.
So watered down, it's a no.
Mr. Généreux.
No.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets.
Oui.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays.
Thank you, Madam Clerk. The motion carries. So, Mr. Généreux, if you wish to carry on with your other motions, please move your next motion.
Let's see if we can get 2 done in a day, Mr. Chair. Wouldn't that be something? All right, so let's move on to, I take it, the motion with regards to interim order. I'll read it out for you, and Mr. Chair, just so you're clear, I've already amended the dates as we had agreed to with the other motions, so I'll read it with the amended dates. Pursuant to Standing Order 1081A, the committee send for the following documents to be provided by the government by Monday, August 31st, 2020, and that the documents be published publicly on the committee's website by Monday, September 7th, 2020. All documents, briefing notes, memorandums, and yes, emails to, from, between Health Canada, the Public Health Agency of Canada, and the Privy Council Office related to the March 18th, 2020 interim order by the Minister of Health entitled Interim Order Respecting the Importation and Sale of Medical Devices for Use in Relation to COVID-19, and the March 30th, 2020 interim order by the Minister of Health entitled Interim Order Respecting Drugs, Medical Devices, and Foods for a Special Dietary Purpose in Relation to COVID-19.
Thank you, Mr. Généreux. Is there any discussion on this motion? Yes, Mr. Whoop, I saw a hand briefly go up there, but it's gone. Mr. Fisher, please go ahead.
Just putting it out there, same as the last motion. This one is very much covered in the OGO one. I won't read that back into the record again. It's the same one that covers all of this. And just put it out there to see if Mr. Généreux would be willing to withdraw this motion and have the information that OGO collects, and we can put that on our website.
I will ask Mr. Généreux if you wish to respond quickly.
Again, no, same reasoning, Mr. Chair. We're a committee, we're our own committee, and it's important that we get this information as it pertains to the differences in this motion. So no.
Thank you, Mr. Généreux. We go now to Dr. Pawlowski. Dr. Pawlowski, please go ahead.
A motion to amend the original motion, and that is by pushing back the date from August the 31st to September 7th. The motion was moved on July 7th, so that's pretty recently, and it would just allow the department a little more time in producing the required documents.
Just to clarify, did not Mr. Généreux already, I think he incorporated that change in his motion as moved.
Yes, I did, and I'd ask Mr. Pawlowski to move to the second amendment that he has on his piece of paper there provided to him from the whip's office, as opposed to the first one. We've already dealt with that one.
Okay, my apologies if the dates are ready. Right.
Thank you, Doctor. I have Mr. Kellaway next. Please go ahead.
Yes, in terms of the amendment, I would put a motion or make an amendment rather around the removal of emails on the first paragraph, first line.
Thank you, Mr. Kellaway. So we have a motion to amend, which will be as previously to remove emails and make appropriate grammatical adjustments. So the discussion now is on Mr. Kellaway's amendment. Ms. Jansen, please go ahead.
I hate to waste time here, but I have to say again, perhaps, not everybody is talking to the right people when they're going out into their constituencies to find out how upset Canadians are and how little trust they have in what we've done on this pandemic. But the idea of, again, not allowing emails to be part of this discussion is something that's going to continue to hurt the trust of Canadians. It is not transparent. It is actually holding back information that would help people better actually believe that what you guys are saying is absolutely true. So we have to really look at the fact that people don't believe what's being said, and how are we going to get them to believe what's being said? Lay it out on the table, open up the books, show them what was said, show them what was done. That's the way to gain their trust. Transparency is absolutely critical.
Thank you, Ms. Jansen. We have Mr. Kellaway next. Please go ahead.
Yeah, thanks, Mr. Chair. And allow me to be transparent. I have no talking notes to this or briefing notes on it. I think one of the hallmarks of this committee is to have real substantive discussion, whether it's from the NDP, Conservatives, Bloc, or my own party. And I think when we get into these generalizations, yes, Canadians are worried. Yes, Canadians want action. But I would also say, when you use the words don't trust, and there seems to be, I wish there wasn't so much of this gaslighting that's happening on this committee in terms of certain terminologies that are used. I'll stand by my belief around the removal of emails, as stated in the last motion. But I think we can have a real good debate without that kind of discussion.
Yeah. Thank you, Mr. Kellaway. You should move your mic up actually a little bit higher when you speak. It'll be better for the interpreters. Mr. Davies, please go ahead.
Mr. Chair, I'm sorry, just clarification. Are we specifically talking about the removal of emails at this point and not the redaction process?
That is correct.
Okay, I'll pass. My remarks will be directed towards redaction. Thank you.
Great, thank you. Is there any further discussion on Mr. Kellaway's amendment? Any further discussion on Mr. Kellaway's amendment? Seeing none, we will go to the vote. So the vote is on Mr. Kellaway's amendment, which is to remove emails from the list of documents to be returned, to remove emails and make appropriate grammatical adjustments in doing so. Madam Clerk, if you would please conduct the vote.
Mr. Fisher.
Yes to the amendment.
Mr. Kellaway.
Yes to the amendment.
Mr. Pawlowski.
Yes.
Ms. Sidhu.
Yes to the amendment.
Mr. Van Bynen.
Yes.
Ms. Jensen.
No to the amendment.
Mr. Généreux.
No.
Mr. Kitchen.
No.
Mr. Weber.
No.
Monsieur Desilets.
Oui.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays.
Thank you, Madam Clerk. So the amendment carries. So the discussion resumes on the main motion as amended by Mr. Kellaway. Is there any discussion? I have Madam Sidhu, please go ahead. Madam Sidhu, your hand was up, I believe.
Mr. Chair, is vote is done. After that, next speaker.
Thank you. Go to Mr. Davies, I guess.
Sorry, Mr. Chair, I'm waiting to speak for, I anticipate the next amendment on the redaction process.
Very well. So is there any further discussion on Mr. Kellaway's amendment to remove emails? Sorry, we're on the main motion, right? So I'm getting back in the game here. So sorry, we're on the main motion. There is no amendment yet on the floor. Mr. Van Bynen, I see your hand is up.
Mr. Chair.
Yes, Mr. Du.
Mr. Chair, I was on the, because I have a trouble speaking. I just want to, on Mr. General's motion, I want to, can I speak? Are you listening? Because I have trouble speaking, listening. So are you listening me correctly so I can speak on the motion?
Yes, you can. Your sound quality seems to be okay right now. Go ahead.
Okay, so then I will go ahead. So, Mr. Chair, I would like to propose the following amendment to this motion. The amendment reads as provided that the department does its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process. As the members know, our federal departments are always discussing issues under provincial jurisdictions with our provincial colleagues. Many of these communications are included in documents which could be caught up in this motion as it stands now. This amendment I propose will ensure the communication and trust between the provinces and the federal government is protected. This is a matter of protecting private information while at the same time ensuring the committee gets the information it is looking for. Furthermore, it's clear that the opposition members also agreed with this at one point, that this language has also already been used in the motion, agree and ogo. So it's reasonable that we use the same approach now, Mr. Chair.
Thank you, Madam Sadu. We go now to Mr. Van Bynen. Go ahead, please. Mr. Van Bynen, you're muted.
Thank you. I was having some technical difficulty. The motion that was put forward by Ms. Sadu was, I intended to do that as well. I support the motion, and I think there's been a very fulsome discussion about this. And so I would just say that I do support that motion.
Thank you, Mr. Van Bynen. We go now to Mr. Davies. Please go ahead.
Thank you. Well, I agree with Mr. Van Bynen that there's been a fulsome discussion, so I'm not going to repeat the points that I've made earlier and that others have made. And I also want to just say I agree with Mr. Kellaway that I also don't take this position on redaction and disclosure based on anything, any negative view of the Canadian public. That's not my motivation here. My motivation here really is to ensure that independent committees exercise our full powers in a way that's independent of the government and in a way that's responsible and in the best traditions of accountability and transparency. What I wanted to add to this is my excellent researcher has sent me the grounds for redaction under the Access to Information Act. So I thought I would just read those into the record so that my colleagues are aware before we vote on this and agree to redact information that we know exactly what we're doing. Here are the grounds under ATIP. Information obtained in confidence, federal provincial affairs, international affairs, defense and national security, law enforcement, investigations and security of penal institutions, safety of individuals, economic interests of the Government of Canada, personal information, third-party information, advice, testing procedures, solicitor-client privilege, statutory prohibitions, and information to be published. So if that's a complete list, and I'm led to believe there are 13 separate grounds for redaction. Those are exactly the grounds for redaction that resulted in the completely unacceptable material that we had delivered to this committee back in February and March. That I think all committee members who had a chance to review that information would, contrary to what Ms. Sidhu said, or her admonition, agree that we didn't get the information that we sought. So I don't know why this committee would now formalize the adoption of criteria for redaction that everyone in this committee knows is going to result in us not getting the information that we want, but rather just getting information that any person in any community in this country can get from this government. We are basically neutering this committee's powers of production, and guaranteeing that we're not going to get the information that the substance of the motion wants. So I agree with Ms. Sidhu. We should be getting the information that we want, but mark these words here, because when we get this information, if this passes, and I must say for the record that I'm a little disappointed in the Bloc agreeing with this, because my understanding is last week the Bloc did agree with a redaction process that would result in more production of documents. So we will revisit this issue back in September when we get these documents, and we'll see whether or not the ATIP criteria results in this committee getting the information that we really want to get. Because if it doesn't, I hope that all of us are open-minded enough then to review this at that time and make sure that this committee can actually get the information that we want. Finally, I would just say, I don't think there's anybody on this committee that wants to harm federal-provincial relations or any other such things. I think that all of the colleagues on this committee want the same thing, which is we're the Health Committee. We have a vested interest, as no other parliamentarians do, to look into in detail matters of fundamental importance to public health in this country. Things like determining, the about face on masking, where we had the chief medical officer and the health minister of this country telling Canadians not only that we didn't need masks, but that masks would be harmful to public health. That's what the position of PHAC was about 3 or 4 months ago. And now we know that that's completely not wise public health advice. And when we're told, by the way, by Dr. Tam that she changed her mind because of recent evidence, for us to be able to test that as parliamentarians, we need to have access to the full information that she had to determine whether that is actually true and whether or not Canadians are getting the unvarnished facts to them. And this is where I think Ms. Jansen's point is well made. The Canadian public may or may not have lost trust in this government, but we risk them losing trust in their chief public health officer and government if we fail them as parliamentarians and don't seek out information when we have such a colossal, blatant about face in public health policy. If we're not prepared to look at that in an unvarnished, courageous way, that's what I think is behind these motions, not a nefarious attempt to violate someone's rights. I'm going to conclude by saying, as you can see by some of these criteria, they are so broad. If we're allowing the vetting for third-party information, for personal information, for safety of individuals, for advice, we are guaranteeing that the documents that we're getting back from this request are going to be so heavily redacted as to be virtually useless to this committee. And again, mark these words, because come September or October, when we get these documents, each member here who votes in favor of this and denies that will be held accountable when we get those documents back, and we'll see if those documents really do provide the information that we really need to see and want to see, as Ms. Sidhu passionately claimed. Thank you.
Thank you, Mr. Davies. We go now to Dr. Pawlowski, please.
I appreciate Mr. Davies' comments, and I think the onus is now on the Department of Health. If they come back with documents that are heavily redacted and basically useless and make the department non-transparent in the areas we want transparency, then it's certainly going to undermine those of us on the Liberal side who are preaching transparency, that we, and I fully agree with Mr. Davies that there has to be that transparency. I have some trust that the Department of Health will do their redactions judiciously. If they do it very liberally and apply everything under ATIP in a very liberal fashion, large parts can be redacted. But I look forward and hope and trust that the Department of Health will do the redactions appropriately and in the best interest of Canada. In the best interest of Canada includes transparency.
Thank you, Dr. Pawlowski. We go back to Ms. Jansen. Go ahead.
I just have to say, Mr. Chair, how disappointed we really are that yet again, we are not going to be allowed to have the documents that we need to ensure that there's complete transparency and openness. I believe that that is very important to ensure that Canadians are confident in the decisions that are being made on their behalf for their safety. And I continue to be extremely saddened that we cannot find a way to be open and transparent at this committee.
Thank you, Ms. Jansen. We go back to Mr. Davies. Go ahead.
Well, I'd like to thank Dr. Pawlowski for those comments. There's one thing I think that's important to remember is I don't think we have to wait to see in September how the department is going to react, because we already have an example of how they've reacted. Again, the law clerk of the House of Commons took the unusual step of writing to the clerk of our committee when they received the documents pursuant to our first request back in February. And I think it's really important for committee members to think about this. I'm going to quote from his letter again. It said here, let me just find the paragraph here. Upon reception of the documents on March 15th, 2020, you provided them to my office so that we could make the necessary redactions to protect the privacy of Canadian citizens, permanent residents, and public servants as contemplated by the production order. However, as mentioned above, the documents had already been redacted by the respective departments. Even though there was an order to the department to provide the documents to the law clerk and let the law clerk do the redactions and redact them only according to the 3 criteria that we had given them, the department took it upon themselves to do the redactions themselves and to redact according to ATIP, when that was clearly in violation of the production order of this committee. Moreover, in terms of Dr. Pawlowski's thought that maybe we can see how they do and then respond, this is what the law clerk said to us in the same letter. As my office has not been given the opportunity to see the unredacted information, we are not able to confirm or adopt those redactions. So once you get page after page after page that's blacked out, there is no way to determine how wisely or responsibly those redactions were applied. So those would be my responses to the claim that, well, let's just see how the department does here and we'll be able to hold them accountable. No, we won't. This committee has one job right now, and that is we have to determine what the criteria are that we're going to give to the department in terms of the documents we seek. And I think it's completely responsible for us to say, send those documents to the law clerk and have the law clerk redact according to specific criteria. If Liberal members of this committee think that those 3 criteria are not broad enough, then the amendment should be to add some more. So maybe add federal-provincial relations or whatever you want to do. But by simply adopting the ATIP criteria, all 13 of them, holus bolus, nobody can look anybody in the eye at this meeting and say, well, let's wait and see. I'm sure we'll get fulsome information from the department in September that'll give us everything we want to know about this. Okay, anybody who is seriously advocating that right now is not paying attention to the evidence that we have before us, which is how they've responded when we asked for the documentation in February and March. Thank you.
Thank you, Mr. Davies. Is there any further discussion on the amendment? So the amendment to Mr. Genero's motion, as previously amended, is to incorporate the ATIP information as we did in the last motion. Is there any further discussion? Seeing no further discussion, I will ask the clerk to conduct the vote on Ms. Sidhu's amendment.
Mr. Fisher,
Yay to the amendment.
Mr. Kellaway,
Yay to the amendment.
Mr. Pulowski,
Yes.
Ms. Sidhu,
Yes to the amendment.
Mr. Van Bynen,
Yes.
Ms. Jensen,
No.
Mr. Genereux,
No.
Mr. Kitchen,
No.
Mr. Weber,
No.
Monsieur Desilets,
Oui.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays.
Thank you, Madam Clerk. So the amendment carries. So we go back now to the main motion as amended. Is there any discussion on the main motion as now amended? Is there any motion on the, so is any discussion on the main motion as amended? Seeing none, I will ask the clerk to call the vote. So please go ahead with the roll call.
Mr. Fisher,
Yes to the motion.
Mr. Kellaway,
Yes to the motion.
Mr. Pulowski,
Yes.
Ms. Sidhu, Ms. Sidhu,
Yes to the motion.
thank you. Mr. Van Bynen,
Yes to the motion.
Ms. Jensen,
Again, watered down. No.
Mr. Genereux,
No.
Mr. Kitchen,
No.
Mr. Weber,
No.
Monsieur Desilets,
Oui.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays.
Thank you, Madam Clerk. The motion as amended carries. Thank you. We go now back to Mr. General. I believe you have another motion you may wish to move.
Yes, I do, Mr. Chair, and it is my final motion. Pursuant to Standing Order 1081A, the committee send for the following documents to be provided by the government by Monday, August 31st, 2020, and that the documents be published publicly on the committee's website by Monday, September 7th, 2020. All documentation from the military report on long-term care homes in Ontario.
Thank you, Mr. General. So we have a motion on the floor, which is the motion to recover or to receive information about the military report. Mr. General has made the date changes as he expects them to be asked for. Is there any discussion on? Okay, we have Mr. Pulowski. Mr. Pulowski, Dr. Pulowski, please go ahead.
Okay, at risk of looking really stupid and making the same mistake twice, do we have the dates right? That now the dates are August 31st, and I'm requesting that it amended to the date of the 7th for published publicly on the committee site, changed from August 10th to September 7th.
Yes, Dr. Pulowski, I believe that is how Mr. General made his motion. Mr. General, if you wish to confirm.
Yes, Mr. Chair, that's how I did it.
Great, thank you. So Dr. Pulowski, the date changes you were interested in have already been incorporated into the motion. So we go now to Ms. Sidhu. Ms. Sidhu, please go ahead.
So, Mr. Chair, I'm in favor of that. Why? Because
Pardon me, Ms. Sadu. Pardon me.
reason as before. And,
Pardon me. Your sound quality's gone bad. Perhaps if you shut off your video, you might get better sound. So if you could try that. So on the video icon at the lower left-hand corner, the little up arrow, you can, actually, that's not where you turn it off. Where you do that? I think in the image of your of yourself on the gallery view, if you click on that image, there's 3 dots in the upper right corner. If you click on those, you can there's one of the options is to stop your video.
Mr. Chair, can you hear me now?
Your sound quality is very bad. I'm recommending that you turn off your video so that the bandwidth is less on your system. So are you able to, if you click on your image on the Zoom window? Yeah.
Yes.
And
how's
there you, that's good. That's good. So
okay.
Try again. Try that with try speaking now.
Okay, Mr. Chair, I would like to propose the following amendment to this motion. The amendment reads as provided that department does its assessment and vetting in gathering and releasing the documents as it would be done through the access to information process. The reasoning for this amendment is the same as before. I believe that adding language like this will ensure that we receive the best information possible while protecting privacy issues such as interprovincial communications.
Thank you, Ms. Sadu. Is there any discussion on this amendment? So Ms. Sadu has moved to amend the main motion by adding the ATIP qualification. And so I have Ms. Jansen. Ms. Jansen, please go ahead.
I just want to say once again that we really should hold ourselves to a higher bar of communication and openness. And yeah, it's just a shame what we're doing here.
Thank you, Ms. Jansen. Is there any further discussion on the Ms. Sadu's amendment? Any discussion on Ms. Sadu's amendment? Seeing none, I will ask their clerk to conduct the vote on the amendment.
Mr. Fisher,
Yes to the amendment.
Mr. Kellaway,
Yes to the amendment.
Mr. Pawlowski,
Yes.
Ms. Sidhu,
Yes to the amendment.
Mr. Van Bynen,
Yes.
Ms. Jensen,
On se reparle.
No.
Mr. Genereux,
No.
Mr. Kitchen,
No.
Mr. Weber,
No.
Monsieur Desilets,
Oui.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays.
Thank you, Madam Clerk. The amendment carries. So we're back to the main motion as amended. Is there any discussion on this motion as amended? Is there any discussion on this motion as amended? Seeing none, I will ask the clerk to conduct the vote on the motion as amended.
Mr. Fisher,
Yes to Mr. Genero's motion.
Mr. Kellaway,
Yes.
Mr. Pawlowski,
Yes.
Ms. Sidhu,
Yes.
Mr. Van Bynen,
Yes.
Ms. Johnson,
Have to say no again.
Mr. Genereux,
No, but just a clarification, Mr. Fisher voted yes to my motion, so I assume that's no to the amendment, Mr. Chair. So that would he would be in the no category.
Yes, sir.
We're carrying on the vote on the amendment on sorry, the motion
Yes,
as
sir.
amended. So carry on.
Mr. Kitchen,
No, like the others, watered down.
Mr. Weber,
No.
Monsieur Desilets,
Non.
Mr. Davies.
No.
Mr. Chair, 6 yeas, 5 nays.
Thank you, Madam Clerk. The motion as amended carries. So that wraps up our business for the moment. We now,
Mr. Chair, I have a point of order. I'm sorry if I misunderstood this, but did Mr. Desilets vote no?
I believe so.
So would that not be 6 noes to 5 yeas?
I'll ask the clerk to verify. Madam Clerk, if you would verify. Sorry, you're muted.
I had Mr. Desilets voting yes. Mr. Desilets, could you confirm?
Monsieur Desilets, did you vote oui or no on the motion as amended?
Mr. Desilets, vous êtes sur sourdine.
Il y a un problème de son depuis 1 minute.
I've been having sound problems for about a minute. There's a delay. So just give me a moment, please.
Mr. Chair, sorry, I clearly heard Mr. Desilets say no. If he's needing to hear from the whip, then I think it's inappropriate. We had the vote. He voted no.
We are just confirming his vote.
This gives the individual an opportunity to have a second vote, Mr. Chair. He had his first vote. He does not get a chance to vote once the vote is done, Mr. Chair.
Je suis contre l'amendement.
I am against the amendment. I am not responsible for the sound problems.
So the vote
Est-ce que vous m'entendez?
Can you hear me?
Ended.
Motion amendée.
So is that how you voted?
Demandez oui. Motion. Si vous m'entendez.
Yes. I did vote on the amended motion, yes.
Est-ce que vous m'entendez, Monsieur?
Can you hear me, Mr. Chair?
So you voted on the amended motion, yes or no? I'm sorry, Monsieur Desilets.
Motion amendée, oui, si vous m'entendez.
Yes, I did vote on the amended motion.
Thank you.
Oui.
Very well. So the clerk's tally stands. The motion is carried.
Sorry, Mr. Chair, I have a point of order on this. I'd like to ask the clerk's advice on this. I want Mr. Desilets to vote the way he wanted, but he did vote no on the motion. And now I don't know what happens in a case like this. Are you allowed to change your vote after the vote has been conducted? Because perhaps you were, you were confused about what we were voting on or not. I don't want to get too technical, but I'd like to know from the clerk what is the proper procedure in a case like this.
Well, I will jump in here. Firstly, we see this all the time in the House. People may vote one way or the other on a bill or a motion, and they stand up later and say, please correct my vote, and the chair accepts that. So I think that's an appropriate process for this. We want people to vote, to be clear about what they're voting on, and if they're mistaken on that, I think it behooves us to accept their correction. And if Madam Clerk, if you wish to give any further insight into this, please feel free to do so.
I can look at the blues after the meeting and put in the proper decisions, or we could suspend and I could go look at Parview right now.
So I think the question, as far as I'm concerned, is not whether Mr. Desilets said yes or no at the time, is whether he was clear on what he was voting on, and he has since corrected his. He's adjusted what he's asked for his vote to be recorded as a yes on that motion. So I'm, as chair, I would rule that that is in order for him to do that, because it is consistent with House practice, as I've observed over the years, that people who have inadvertently voted wrongly on a given matter have been allowed by the chair, by the speaker, to correct their vote afterwards. And Ms. Jansen, you have a comment.
I'm just curious how it is that the clerk counted his answer as a yes when he said no. How did that happen exactly?
I'm sorry, that's how I registered it, but I would be happy to look at Parleview or the Blues of the meeting.
In any case, Mr. Desilets has clarified that he intended to vote yes on the motion as amended, and I will let that stand. So that being the case, we have finished Mr. Genero's motions. So we do now have the schedule to do an in-camera meeting for instructions relating to the report that we're going to do on the COVID-19 study. To do that, we have to exit this session and log back in to the other section. You guys have all presumably received the link for that with a separate password. So we will suspend for the moment, and we will resume in camera on the next Zoom session. So please make sure you log into the next Zoom session. Thank you.
you.